Good morning and welcome to this morning's Knowledge Bank. My name is Vicky from News on the Block, and today's session is being brought to you by Howe Chartered Surveyors. They will be discussing Section 20 major works. The webinar is going to be split into three sections presented by Christian Howe, Spencer Futter and Daniel Bailey. After each section, the presenter will be taking questions. So if you have any questions, please submit them via the Q&A button at the bottom of your screen, and we will try to get through as many as we can. The session is being recorded today and will be available to watch back via our YouTube channel. I will also be sharing slides for anyone who would like to see them. So without further ado, I will now hand you over to Christian to begin the session.
Hello everybody, and welcome to our presentation on Section 20 major works. Thanks for joining us. So I'm just going to start off by giving you a bit of an introduction to Howe Chartered Surveyors and talk about the role of the surveyor as regards Section 20 works. That's going to be followed on by Spencer Futter, who's going to talk about surveyors' contribution to the project process, which is going to be the main body of the presentation today. And finally, Daniel's going to close things off regarding conflict avoidance, means of resolution, which I'm sure all of you have probably been involved with in some way, so will hopefully be very helpful to you. Okay, so as regards the introduction and the dual roles, these are the topics that I'm going to cover for you today. Howe Chartered Surveyors was established in 2013, and it was just myself at that point, and I had a small office in St Paul's. We opened an office in Brentwood in 2015 and took on a few staff. From there, we grew up to 11 in 2018. We got a Growing Business of the Year award in Brentwood. And in 2019, we got the Professional Services Provider of the Year at the PMAs, and some other awards. Throughout the pandemic, we moved our London office, so we're now on Bishopsgate, 99 Bishopsgate, and we've picked up a number of other awards in the interim, and we're now around about 20 staff. So who are we? There's myself. The Ops Director is Natasha, Spencer and Dan, who are presenting to you today. We have Senior Surveyor Stephen, Intermediate Surveyors Sean and David, and we have two newish starters, Harry and James. In terms of structural engineering and architectural design, interior design, we have Liz, Stephen and Tom. And the accounts and business development team are Caroline, Lucy, Eve and Natasha. So the services we provide, generally the ones on the left of the screen are the ones that are possibly more applicable to the people watching the presentation today. So PMPs, CapEx, whatever you want to call them, major works, obviously we're talking about today. Defect diagnosis, license to alter, RCAs, lease extension. Then on the right, we've got other services we provide which will and may not be useful to you. These things tend to cross over quite a lot. So you may need an architect, you might need a structural engineer in involvement with some of the other services that you use. So moving on to the dual role of the surveyor in terms of Section 20. Now, this is an area where there's often quite a lot of misunderstanding between the employer and the contract administrator. So if we were contract administrator on a project and we've got a residential block, we are engaged by them, fees are agreed, etc. And we put together a design, so we're doing an external redecoration refurbishment program. There might be a few drawings, there will be a specification of works put together, etc. That will be tendered, and then we'll write a tender analysis, a tender report, and a contractor will be appointed. So up to that stage, we're wholly working for the employer. It's a discrete design period. Once the contract is then formed and we move into a contracted administration role, so now we've got a contractor, we've got the employer, and then we sit there in the middle most of the time. So there's some impartial decisions that we need to make throughout the contract in terms of variations. So if we're making contract instructions, for instance, you put the scaffold up, you find that there's a lot more repairs needed than was anticipated. So you need to increase the amount of repairs that you're making. So that needs a contract instruction, which is going to increase the value of the contract. Excuse me. So we need to be impartial in that position, in that situation. It would be unfair on the contractor if we were to say, okay, well, no, you can't have £10 a repair. We're only give you £5, even though we know that £5 is actually the correct amount. It needs to be impartial, otherwise the contract won't work. Similarly, an extension of time. We probably all know what an extension of time is, but if we get to the end of the contract, they don't finish within the specified amount of time and the completion date, then they will claim for an extension of time in order not to receive any liquidated damages, etc., further costs. So we have to make an impartial judgment as to whether they should be given that extension of time, i.e., what were there things out of their control which made the contract overrun, or were they within their control? So these are the impartial decisions we have to make, and sometimes the employer doesn't understand this from the outset, and therefore it can become a bone of contention because they feel like you're not acting on their behalf. But legally, we have to be impartial. So we like to be very upfront with that, and from the very start, when we're employed, we'll explain what I've just explained to you just now. That's not to say that during the contract some of our advice isn't impartial. We can still give advice to the employer regards strategies, best ways to do things, etc., and be wholly on their side. But there's just certain impartial decisions that we need to make, as I've laid out to you just now. So what is the role of the surveyor? What are the things that we're doing in the Section 20 situation? So predominantly we're doing project management and contract design. We're preparing the contract, we're tendering the works, and then we've got these other things that might come in. These are additional services generally. So there might be some architectural design, there could be some landscape design, there could be some structural design. We might have to deal with some statutory approval, so then planning could be required, building regulations approval, party wall may also be included. So when we start off, we need to understand everything that's required, and then we can, it's not to say it can't be included in the original fee, but we just need to have our eyes open as to what the requirements are. So at what stage should you get the surveyor involved? Okay, well, from the outset, of course. And what's the reason we say that? So what we can do, this links back to the previous slide. We can identify what the works are to start with, what services are going to be required. Are we going to need a structural engineer? Are we going to need an architect? Also, what are the priority works? And we can put the CDM in place. We can design out any issues, and we can give contractual design advice and choose the right contractor for the job. So it's really important to engage your surveyor early. It won't make any difference to the fee that you pay, but it could make a lot of difference to the outcome of the project. So how can you appoint a surveyor? Again, most of you are probably aware of this one. You can retain a surveyor, excuse me, who works for the block with all of the works they do throughout time, or you can directly appoint a surveyor just for that specific job. It could be that there's a competitive selection, or they could be in-house surveyors that the managing agent use. Cdn, this is my last slide, which is probably a good job given I need a long drink, I think, is something that needs to be considered and probably will be, well, it's always applicable, but will be triggered in terms of notifying the HSE with most of the jobs that you're involved with. So what is the application? As it says on the slide, any job over 30 working days and with more than 20 simultaneous workers at any one time. And what is done in the CDN process? The design is reviewed, pre-construction information is provided in the specification to cover off any CDM issues. The construction phase plan is reviewed, which is provided by the contractor, but reviewed by the consultant. And then at the end, we will put together a health and safety file for you to take forward for any further work that the block may do. You know, okay, where was asbestos found, what was removed, and things of that nature. Okay, well, thank you for listening. The summary is that we have a dual function as surveyors. We're an employer's agent, but when we're a contract administrator, we have some impartial functions. It's important that that's understood by the employer. You should engage the surveyor early to get the best output. And don't forget about CDM. Make sure that that's been included in the fee that the surveyor gives you, or you've sourced that some other way. Okay, I'll take any questions.
Hi, Christian. I can't see that we have any questions at the moment. If anyone does have any questions, then please submit them now before we move on to the next section. Just give it a moment.
Okay.
Okay, no, we haven't got nothing coming yet, so if you'd like to move on, and then if we have any questions at the end, we can come back to them.
Yeah, thank you. I'll hand over to Spencer.
Okay, thank you, Christian.
Good morning, everyone. Thanks for joining us. Yeah, mine's going to be a slightly longer portion of the presentation, as I'll be covering the surveyors' involvement within the Section 20 process. So as I go through, we're going to be talking about the initial stages once the surveyor's been appointed, and the surveyor's role in relation to the different stages of the Section 20 process. So talking about agreeing the brief, developing feasibility, then obviously looking at the final agreed design, contractor selection, preparation of tender documents, the tender analysis process, and then obviously the appointment of a contractor and then contract administration. So the first stage, and probably one of the most important stages from a surveyor's perspective, is to meet with the client and identify a clear and defined brief. Now, within that clearly defined brief, what we're talking about is understanding the full extent of the desired works, what funds are available, and also what the timescales are for completion of the work, or any other time factors that might be involved. This will enable the surveyor and the employer to understand the time, cost and quality expectations for the project. These are typically the measures by which the employer will judge the success of the project, and so that needs to be a real focal point for the surveyor throughout the process. Every client has a wish list. Tenants, residents may look and say, these are the works that I'd like to have done, but there may be some prioritization needed within that agreeing the brief process, and so not all of those desired works can be afforded within the budget. As such, the surveyor will use various means to help to define that brief and to rationalise what works are priority. There are different ways to do this. Condition surveys such as PMPs or CapEx plans are a great tool for identifying urgent work and planning major works over an extended period of time. Within that, often there's costs or budget costs prepared as part of that feasibility process. That involves not just sticking your finger in the air and hoping for the best, but what we do is we use a variety of pricing indices such as SPONS, the BCIS, and also current tender returns, which give a real indication of what the market is looking like in relation to actual costs for when works are undertaken. So by undertaking these condition reports and identifying the budget costs, it can really help in prioritising the work that needs to be done and helping the employer to have a real understanding of what they're committing to, particularly financially. So if you have blocks or a block that you don't have a planned maintenance program for, or a CapEx, we recommend that you undertake that as a very early step. So, as Christian mentioned, another role of the surveyor is to identify other associated costs, fees in relation to structural works, if there's additional design required, architectural or interior design works, but also to identify any statutory fees, such as planning and building control. The surveyor should identify what planning is required in relation to the desired works. Obviously, different properties in different locations will have different planning requirements. Some may be listed and in a conservation area. Others may just require full plans, or other elements of the work may be permitted without full planning approval under permitted development rights. So the surveyor will identify these requirements, and if appointed to do so, will prepare and submit the planning application to obtain the necessary approvals. Likewise, with building control, the surveyor will know, or should know, what aspects of the work are subject to building control and the building regulations approved documents, and design those works appropriately so that they are applicable to meet those requirements. And again, if appointed, will prepare the actual application. Now, there's two options in relation to obtaining building control approval. You can go through the local authority, building control office, or you can employ an approved inspector. Now, the approved inspector has delegated powers to give statutory approval, but as the approved inspector is directly appointed by the client, they are working for you. So what we tend to find is that they will not help you get around things, but when there is a conflict, particularly when working on existing buildings and you're trying to work to the most current and modern regulations, there are often those times where there's a conflict. And rather than potentially having the local authority just say, what you've proposed doesn't work, the approved inspector will work more closely with you to try and find the right solution where a compromise is required. So there's a benefit there. So in relation to the section 20, the question we ask is, what is the purpose of that first stage notice? We're engaging with the residents, but this first stage notice, you know, what is the purpose of it? And so here we can see that we're confirming the brief or the outline scope of the works to the residents so that they understand what is being proposed. This gives them opportunity to ask questions. Why are the works required? You know, are we doing enough? Are we doing too much? Whatever their questions may be or concerns. They may also be looking to do additional work. It also gives them the opportunity to nominate contractors, and the suitability of contractors for the works to be undertaken is a real key or an important factor in the success of the project. When we are undertaking works, Christian mentioned CDM, which is the Construction and Design Management Regulations 2015. They're the most current. And within those regulations, it sets out responsibilities for all the parties involved in the project. So the clients, the contractors, the designers, everybody has a responsibility. So when selecting a contractor, you want to be certain that they can fulfill their requirements in regards to CDM. So here on the screen, we can see some of the responsibilities that the contractor will have, and they're not necessarily light in terms of their responsibilities. So not all contractors are suitable for all types of work, and depending on the scope and scale of the project, some contractors just aren't suitable. So as a surveyor, you know, we're looking at these contractors and we're trying to understand what their capabilities are. Sadly, when residents are nominating contractors, they may not be looking at as closely. It may be a friend, it may be a family member, whatever their relationship is. But as we know, under the Section 20 rules, they can't be discounted. They have to be included within the process. So it's really for the surveyor to determine their suitability as part of the tender analysis or the tender process and make that clear as to whether they are considered suitable. So at Howe Chartered Surveyors, we have an approved contractor list. We have a pre-qualification questionnaire that we use, which helps us to understand and determine the suitability of the contractor in relation to those things that you can see on the screen in terms of health and safety, management of subcontractors, financial stability, which we look into to appoint, and obviously the organisation of the contractor. So that's the early part of that first stage notice. We've identified what works are to be done. That notice has gone out. It's 30 days or thereabouts for that consultation period. But when can the works actually be tendered? Well, not until that process is finished, because obviously the contractor needs to be, or the contractor list needs to be agreed for that tender process. So that section process is over. We've got a design freeze in terms of this is the work that they want to proceed with. And then if appointed, the surveyor will then prepare the tender documents. And this will include the items that are listed on the screen. So the preliminaries, which are the contract particulars in relation to the contract, in relation to the contracted works, materials and workmanship, which really sets out, these are the materials that are going to be used, or systems that are going to be specified, and these are the workmanship requirements. So it really relates to the quality of the work. Day rates, that identifies a cost aspect, and obviously the scope of works, which is the full detail of the works that are to be undertaken and the associated information that relates to the cost and quality requirements that again relate back to that initial briefing. So you can see here from all these different components that we're trying to still maintain those time, cost and quality requirements that were set out from the start. So then the next stage is really, we're going into this second stage notice. The surveyor has done the tender package. They then have the contractor list that was agreed off the back of the first stage notice, and we're then issuing these tenders to the contractors, and this can be through a variety of different tender processes. Traditional single stage tender is probably the most common, but there are other means of tendering these works, e-tender and other methods such as that. So the surveyor will oversee that process. They'll answer any technical questions and pricing queries, and once they have received those tender returns from the contractor, they'll undertake a detailed analysis of those tender returns. The purpose of that is to make sure that they are comparable and that they are a fair representation of the works that have been tendered. In doing so, the surveyor will make a recommendation with that tender report of which contractor is to be used. So once those tenders are back and the tender report is submitted, it's over to the property manager, whoever is managing that Section 20 process, to convey that information in the second stage notice to the residents. And what does it tell them? Well, it tells them the tender results and the selected contractor, or the nominated contractor. It identifies or outlines any demands for funds that may be over and above what's already within the budget, and that includes all the surveyors' fees, any statutory fees, etc. If the nominated contractor is not the lowest priced contractor, then there is the requirement for a third stage notice to identify the reasoning why the lowest priced contractor has not been selected. And again, that could come down to them just not being suitable for the work, and that their tender price or their tender submission doesn't really reflect the time, cost and quality represented in the tender. So once a contractor is selected and the sufficient funds are in place, the contractor can then be appointed, and this is normally done in the form of a formal building contract. It should be signed by both parties, and ideally before work commences on site. The contract really is the means by which the contract administrator can manage the contract. It sets out for both parties their roles and responsibilities, and it also sets out the mechanisms by which disputes are to be managed and hopefully avoided. The type of contract to be used is something that the surveyor will have advised on in advance of the tender process to make sure that it's suitable. And Dan is going to talk a little bit later about the different types of contracts and why it's so important to choose the right one. So the contract, as I said, the contract should be signed by both the contractor and the client, as I said, before the works begin. It's not always possible, and in those instances, a letter of intent may be used as an alternative, not as an alternative to having a contract, but just if it can't be signed in time before the works begin. There is a hesitation with this. They should only be used if you've got experience of using them. Using them without real understanding can often lead to difficulties and other potential disputes. Just as a point at the bottom there, as Christian talked about before, the actual signing of the contract formally initialises the role of the contract administrator, and so therefore begins that dual role where the contract administrator has to take on that role as impartial decision maker. So as contract administrator, on the screen you'll see a number of the tasks and responsibilities that they hold, and it's really applying the mechanisms of the contract. So for a contract administrator to really fulfill their role, they need to be familiar with the form of contract that's being used, and that's really important. They also need to understand the requirements of the specification and all its component parts, as this is ultimately what is appended to the contract, and so they need to understand what those requirements are. Other roles and responsibilities are technical in their nature, in understanding what the requirements are of the specification, but ultimately the contract administrator's role is to manage change, which is constant within any construction work with unforeseen events and the like. And so really the role of the contract administrator is key again in the success of the project. And Dan will speak shortly about some potential conflicts that may have an impact. So in summary, it's important to agree a clear and defined brief to understand the time, cost and quality implications. Communication throughout in the form of that Section 20 process is also an important factor. Early identification of statutory requirements and having those ticked off so there's no unpleasant surprises on site. Contractor selection and the effectiveness of the specification and the contract administration to deliver success in relation to the time, cost and quality requirements. If anybody has any questions, I'll be happy to answer.
Hi Spencer, we do have a few questions coming, so I'll see if we can just get through a couple of them before we need to move on.
Okay.
So the first one is, if the proposed surveyor fees exceed the Section 20 threshold, do you need to consult under Section 20 on the surveyor fees? If so, what happens if during the project the fees exceed the threshold but wasn't expected to at the outset of the project?
The fees and the work itself, my understanding is that they will all be added together to make that threshold. And with the, depending on the size of the block, obviously that will affect how high that threshold is. But yes, if the surveyor's fees exceed that threshold, then that in itself would require Section 20 process.
Okay, thank you. The next question from Richard. Given the high costs of scaffolding, are there any other viable options for working at height that could reduce the costs? He says that he's just completed a £300,000 external decoration project over 7 months for the block, and almost half of the cost was for scaffolding and not the actual painting and repairs.
Okay. Again, that's very kind of niche for the particular building. There are different means by which you can access works, depending on the nature of it and the frequency of access, if that makes sense. So in some instances, we've managed works where abseilers have been used to undertake maintenance work. That again is more related to small localized repairs, where if you're doing a full external redecoration or maintenance scheme that requires access to the entire facade, then scaffolding is probably the most suitable means of access. But again, it's a hard one to answer without details of, you know, the actual arrangement of the block and the nature of the work.
Yeah, sure. Okay, I'll just see if we can do another one. There's quite a lot of questions here, so we might need to see if we have time at the end to come back to some. There's one more. Following a consultation, the scale or cost of a project has increased following further investigation. Must the entire consultation be restarted, or can the leaseholders simply be notified of the increased cost prior to collecting the additional funds?
At which stage is that? Is that the initial stage one?
They've not stated.
Okay, well, I'd say that if the works increase during the actual construction phase, then my understanding is that the second stage, or sorry, let me start from the beginning. The first stage outlines the nature of the work. If the nature of the work hasn't changed, then you don't have to restart the process in its entirety, because the actual nature of the work is the same. If after the tender and the second stage notice, the works increase beyond the available budget, then additional demands will need to be made, and I assume that the second stage notice or a further second stage notice would then need to be made for those demands, but the whole process itself, I don't believe, would have to begin again.
Okay, thank you. How long have we got? We've got 2 more minutes. I'll do one more question and then we'll see if we have time at the end. Would the contract administrator be the surveyor or someone employed by the surveyor? Vicky asked that question.
Typically, it is the surveyor. We fulfil, as Christian said at the beginning, that dual role of we'll do the design and be the client technical advisor, and not just technical, but their advisor, but then we'll also take on that role of contract administrator. It can be a separate project manager, but project management is a different role. Different contracts will term them as a project manager rather than a contract administrator. But if it's pure project management, that's not necessarily administering the contract. So I think, as I said, having that understanding of how the contract works, but also that technical understanding in relation to the specification is really important. And that's why, certainly for us, the surveyor who has been designing and managing the project also continues on to do the contract administration role.
Okay, thank you. Okay, I think we'll have to move on then. So we've got time for Daniel's section. If we can't get through all of your questions today, they will be passed on, and the gentleman will try and get back to you with their comments later. Thank you.
Much. I'll hand over to Dan.
Thank you.
Okay, thanks, Spencer. So I'm going to be talking about conflict avoidance means of resolution, as my colleagues have said. So addressing the issues before they arise, or having a plan to deal with issues as they arise, is really the point here. So there's many different forms of conflict avoidance, although running away isn't one I'd recommend. Some reasons for disputes might be a change in scope, a change in design, inadequate contract management, unclear information, poor quality of work, lack of resource, and unrealistic expectations. I'm sure there are a few more, but mainly it's centering around uncertainty, contracts and behaviour, which usually all come back to money. Christian and Spencer have already noted a few of these in their presentations. Identifying works and forming well thought out budgets and briefs, specifications and setting rules are all things that are used to reduce the chances of conflict. So we'd all prefer to reduce the conflict to completely, but sometimes it doesn't happen. So there must be a means to an end, and we'll discuss this as well. So you pay me, otherwise I'm not doing the work, and I'm paying you, I'm not paying you until you've done the work. Well, I'm sure you've probably heard things like this before. I don't need to tell you that contractor is the first one and the employer is the second one, usually. You may have experienced this situation before. It's quite a deep topic, so I'm only going to be able to scratch the surface in the time that I've got. Who is correct? Well, let's come on to that a bit later. So let's look at the basics. What is a contract? Well, simply put, it's an agreement between two parties. So it's I agree to carry out the works for X, and I agree to pay for the works in the sum of X. You can make agreements, but what happens if it breaks down? Well, that's why I'm saying it's all fine until it's not, because the contract will set out the details of the agreement. On the right here, you can see there's a list of headings that are typically in a contract. So I'm just going to run through all these contracts. No, I'm not running through this contract, you'll be glad to hear. But confused.com, right? So I'm going to, each have their own pros and cons, and some are more appropriate than others. What I'm going to do is just run through a quick bar graph here, just to demonstrate the difference of contracts. So contract number one it's refurbishing 3 blocks, let's say. And contract number one allows sectional completion of those blocks. So, you know, the red one completes within 3 months, the black one completes at 6 months, and the grey at 9 months. So you can see we can set out dates when those blocks must complete. Whereas contract 2 doesn't do that. It gives a start date and an end date, and the contractor must complete those 3 blocks within that period of time, not giving any preference to one or another. So you can see that there are some pros and cons here about getting the property back in time, and residents in, or etc., and that it releases retentions. So there are various things that you may or may not need in certain circumstances. A few of the different types of contracts here, just to give you an overview of some pros and cons. So design and build, you might have single point responsibility, but you might lose the control of the design. Whereas management, they are typically very quick and early involvement, but you might lose the cost certainty. So partnering reduces disputes, but it can be abused in certain situations. So you need to understand the contract mechanisms, the client aspirations, the outcomes of the objectives to give you the best chance in that particular project. And it isn't a one size fits all, as I'm sure the message is kind of coming across. But having this process reduces the chances of conflict and provides a vehicle to manage it. Well, what happens then if there isn't a contract? Does it have to be signed and in writing? Well, the answer is no, it doesn't, but is certainly better if it is. And that's what we'd obviously recommend, that you have a contract. There are some key points to know if you don't have a contract, but the Construction Act still applies. You're not entitled to some dispute resolution procedures, which are quicker and less expensive, usually than other types, which I'll mention a bit later on. The contract can't be extended, and the contractor must carry out their work in their own time, which there are no mechanisms for assessing extension of time, or loss and expense. So the employer cannot claim liquidated damages for overrunning works. You'll essentially have far less control, and disputes often result in expensive claims. This is why, if there is a lack of clarity in the rules, the result will be far less certain. Claims can be made, of course, but it's through common law and litigation. So coming back to the slide earlier, you pay me, otherwise I'm not doing the work. I'm not paying you until you've done it. Contract sets out the payment terms and mechanisms, contract instructions, valuations and delays. So therefore, you can see that the contract administrator can use the contract and their experience to facilitate the works rather than it stopping, so helping the works to carry on. The contractor must carry out instructions and can't unreasonably refuse to do so. So they should do the work, and the employer should pay for what has been carried out reasonably. And that's where the contract administrator role is, to facilitate the works whilst giving confidence that yes, they are going to get paid the reasonable amount. The contractor can substantiate their claims with backup information, but confusing bundles of information aren't helpful for contractors to submit, and there must be a clear link between the delays and the works and substantiating it. So the contractor cannot unreasonably refuse, and the contractor will be paid. So the key line here really is to take away is that it should be fair and reasonable and undertaken from an impartial basis, which obviously the contract sets out. So the contract administrator is always employed on this basis, and I think Spencer was alluding to earlier, the contract administrator must have reasonable skill and to do so. So it can't be someone who isn't experienced in that, or it shouldn't be, because that will not carry very much weight when arguing about it later. So what do we do to deal with this? Well, as already mentioned, we set up and agree instruction processes. We record site inspections, we record information, we note and manage delays, we value and manage the works. We use early warning notices, such as sort of predicting disputes, giving contractors and clients information up front to understand what's coming down the road. And the experience of a contract administrator and knowledge of contracts is a very powerful tool in order to facilitate these the works. What happens then if there are disputes? Because as I mentioned earlier, there will be, or there can be, and you can't rule out that won't happen. So negotiation is at all stages. You can negotiate at all stages of the dispute resolution. So obviously that's just an agreement between the parties and a fair and reasonable process. There's no set duration. Arbitration, adjudication, conciliation, mediation are a secondary type where generally they conciliation develops options and alternatives and advisory and seeks to resolve and recommends. Mediation is by a third party, so it seeks to achieve a mutually agreeable solution, but expresses their opinion. So they might say, we don't think you've got much of a chance here, or we do think you've got a chance here, etc. But it's not binding. Whereas moving on to stage 3, arbitration is a private and more expensive, but it can be referred to as litigation without the lawyers, and the decision is binding. You will get a report from an independent arbitrator, and they will say, we think that X amount is due by this party, or this is the final account, or whatever the argument is. They will have a decision. Expert determination and litigation are obviously much more expensive, and generally I'd say that these approaches are more taken out when there is not a contract. So overall, remember that a good negotiation shouldn't feel like either party wins. You should have a clear agenda of the differences and seek to resolve them. In summary, what is conflict avoidance? Well, it's putting things in place, the correct mechanisms, clear communication. Listening is very important, and so my wife tells me. Records. Always keep records of the project as it progresses, minutes, site visit records, etc. Helping people understand the problems and try to resolve disputes. Neither party wins or loses sort of mentality, and the fact that there is an alternative dispute resolution that sits behind that as well. A couple of quotes here that I quite like. When you're at the edge of a cliff, sometimes progress is a step backwards, and that conflict is neither good nor bad, but properly managed is absolutely vital. So I think they're quite good summaries of what conflict avoidance is. And that's it. Thank you for listening. I'll take it.
Hi, Daniel. We have got a few questions here, so I'll just jump straight in. So the first one is, I have a scenario where we have a roof leak and we have sent a cherry picker up. Under section 20 limit, the contractor advised that they need to get a clear idea of what's needed and cannot confirm the work needed until scaffolding goes up. This is now over the section 20 limit. Where does this leave us? As on one hand, we can't start work as we do not know what is needed, but on the other hand, the scaffolding is over the limit.
I don't think that's a conflict one necessarily. Could you just read the last part of that again?
Yeah, they just basically they want to know where would it leave them, because the work is basically over the limit of the section 20, but they can't start any work on one hand because they don't know what they need, but the scaffolding that they need to find out is over the limit basically.
Over the limit of the
section
notice.
The section 20 notice is what they've said. Yeah, it's over the section 20 limit.
I'll step in here. Well, I think we all come in now, then we can.
Yeah, I think there's a mixed bag of questions, so it's probably helpful if you're all here as well.
So I think with the one that Dan's just been asked there, the 250 limit, yes, will apply, but I mean there can be dispensation. So therefore, so for emergency works, if this falls under what's deemed to be emergency works, and you need to put that scaffold up to have a look at what's going on there, then that's a way around not having to serve the section 20 notice. But you do need to get dispensation from the tribunal to do so. So you need to look into that separately, and managing agent or a solicitor can help you with that.
Okay, thank you. I hope that answers your question. So someone has asked, please can you explain the difference between minor work contracts and major? Our leaseholders were confused by this, as section 20 consultation relates to major works, but most contracts will be of the minor variety.
Yeah, I can take that one. So minor works, JCT minor works, there's going back to the slides, if you remember, there was intermediate, there was NEC forms of contract. They are written in a way that is relevant to the works. So even though you may think that they're major works, the actual contract rules and mechanisms in order to manage those works are less perhaps than let's say an intermediate contract or a standard building contract, because you don't need to have so many rules in place to manage those types of work. So although it can be confusing, the works called major in your eyes, they may be using a minor works contract, which doesn't mean that the works being undertaken are necessarily minor. So you could have a lot of works, but actually the works don't require so many controls.
If I could add, I think it's a terminology thing. Obviously, major works are works that trigger a section 20. That's the term that's often used. But the minor works term relates to the type of formal contract that's used. So they're not necessarily talking about the same thing. It's just that terminology for the different elements.
Okay, thank you. I've got another question here from Lewis. What measures can be put in place to ensure tendered quotes remain valid for the full period of the consultation process? In addition, if the work's costs come back much higher than expected, what can be done to try and retain the costs as per the tender if time is needed to coordinate the necessary funds?
Okay, this is a very difficult one at the moment because contractors don't want to hold their prices given the cost of living crisis and the cost of materials, cost of labour, etc.
Mm-hmm.
Within the specification, you will prescribe how long the tenders need to stay open for. So that should be done with consideration to the Section 20 procedure. So that's one way of controlling it. I mean, typically, I think we used to put in 6 months. They needed to stay open. Now we've reduced that to 3 months. What you need to be careful of is, though, if you give a longer period of time, then they're going to price more risk into the specification. So you're going to pay a higher premium for the work because they don't know how much inflation is going to affect prices over the next 6 months or however long. So really it's about being smart and finding the right amount of time that you need to stipulate the tenders stay open for, so that it gives you enough time to make sure all your Section 20 process is complete, but doesn't go any much longer than that, so that you don't pay a premium.
Okay, we're nearly out of time. I'll just ask you one more question from these. Someone else has asked, do your fees include issuing the Section 20 notices?
No, we don't deal with that aspect. That would normally be dealt with by the managing agent. No, we don't deal. It's not, as I understand it, an overly onerous task. It's fairly simple, and a managing agent would easily do that for you, or I know some blocks do it themselves. So it's not, as I say, it's not overly onerous. It's quite easy as long as you follow the requirements of what needs to be in the notice. Then that should cover you off. I just wanted to pick up quickly on a question that was asked earlier, just to be clear. Regards surveyors fees, they don't fall under the Section 20 £250 limit. They fall outside of that. So you can employ a surveyor to write you a specification. You don't need to serve notice to do that. You need to serve notice to say your first stage notice to say this is what we intend to do. You can then employ a surveyor to do the work, to specify and put out to tender, etc. And once you've got those tenders back, then you disclose figures to the leaseholders on what the tenders have come back at, and at that time you also let them know what the surveyor's fees applying to that element would be. It would normally be a percentage of the contract sum, so you will stipulate, so it was 10%, it's a £100,000 contract, and it'll be £10,000 in fees.
Okay, thank you for clarifying that. I think that's basically all we've got time for today now. I'm sorry if we couldn't get through all of your questions, but I will pass them on to the gentlemen, and then if they want to come back with any comments, then they will try and do so. Thank you all for your time today. Thank you, Christian, Spencer, Daniel, for your time this morning in presenting. I did mention earlier, but the session has been recorded and will be available to watch back later. I will also send a copy of the slides to everyone, as I know quite a lot of people have asked for them. If you're interested in joining us for our next session on the 29th of November, we will be discussing compliance with building safety regulations. So you can sign up on the News on the Block website for that. Otherwise, thank you again for your time, guys, and thanks for joining us. Enjoy the rest of your day.
Pleasure. Thank you.
Thank
you. Bye.
Bye.
Bye.